welcome everyone to our third PPE conversation this year. My name is Jeffrey Sigalet. I'm an assistant professor of political science here at UBCO, and I'm the director of the UBC Research Group for Constitutional Law. It's my pleasure today to welcome our guest speaker, Professor Dwight Newman. Dwight Newman is the professor of law at the University of Saskatchewan and the Canada Research Chair in Rights, Communities, and Constitutional Law. He earned his DPhil from Oxford University in 2005 under the great public law scholar Timothy Endicott. Prior to that, he earned a BCL from Oxford, his JD from the University of Saskatchewan, his BA in Economics and Philosophy from the University of Regina. He also holds a graduate degree in theology, which I noticed some of the theologians in the crowd, the one theologian in the crowd, spark up about. He has a Masters of Theological Studies from Regent College, which I find particularly impressive given the rest of his CV. Professor Newman is one of Canada's preeminent scholars of constitutional law, jurisprudence, and indigenous rights law. Last week, Justice Sheila Martin of the Canadian Supreme Court announced her impending retirement. And I would say, in my view, that it's very reasonable to say that, setting politics aside, Professor Newman would be widely considered one of the most qualified bilingual jurists in Western Canada for her Western Canadian seat on that court. We are so lucky to get to hear from him today on a topic that has many British Columbians and indeed many Canadians very concerned about the relationship between Aboriginal rights, Aboriginal title, and property rights. Before turning things over to Professor Newman, I just want to say one last thing, which is that we are very grateful for the support of the Institute for Liberal Studies, who has helped make this series possible, and indeed today possible. So, without further ado, please join me in welcoming our guest, Professor Newman.
Well, thank you for having me here, and I'm really grateful to Jeff Sigalet for the invitation to speak here, and to the Institute for Liberal Studies for supporting the event. I've been privileged to come to Kelowna a few times in connection with the UBC Research Group for Constitutional Law that I've been associated with the last few years, and it's always great to come back and to get to talk today about a really interesting recent case, a very impactful recent case. I think probably everyone here has heard lots about the case in some ways already, but I do still want to offer some backdrop to it before I go on to talk about some of its implications and ways of responding after Cowichan in ways that can be respectful of everyone's interests, both indigenous communities and non-indigenous communities. But in the course of doing that, I may say things that annoy everybody on all sides. We'll just have to see how things go. The Cowichan Tribes decision came out from the British Columbia Supreme Court, which is British Columbia's trial court, as I'm sure you know here in British Columbia, but which people outside British Columbia sometimes are confused by the name. The British Columbia Supreme Court issued the Cowichan Tribes decision in August. And perhaps they thought that, like many lengthy Indigenous rights cases, it's on the lengthy side at over 800 pages. A lengthy Indigenous rights decision issued in the middle of summer holidays, that it might not attract all that much detailed attention, that people would realize that there was a decision, but that they wouldn't necessarily be so engaged with it. If that was the expectation, of course, that was rapidly proven wrong because of some of the potential implications of this case. The case concerned, in part, an Aboriginal title claim by the Cowichan, who are based mainly on Vancouver Island, within the city limits of the city of Richmond on the Vancouver side. And that's interesting just in itself. There are other aspects to the case, I'll mention, that haven't received as much attention in the general public discussion of it. but that are also significant. There's a fishing rights element to the case where there's an order there. That involved especially a conflict with other indigenous communities, with the Musqueam and the Tsawwassen, especially around the fishing rights claim, although there's some element within the Aboriginal title claim as well. The claim within the city of Richmond by the Cowichan was specifically against federally owned land and land owned by the city of Richmond. At least that's all the land against which they sought a specific order by which that land would be transferred to the Cowichan. However, the Aboriginal title claim area was put forward in relation to the area that they thought met the test, and was put forward in terms of an area within the city of Richmond that happened to also cover private property. And because the specific order sought was with respect only to federally owned lands and lands owned by the city of Richmond, an earlier judge within procedural phases of this case had made a decision that there would not be a notice given to any private property owners within this claim area on the basis that their interests weren't directly affected by the case. And in one sense, that's right. In another sense, their interests are pretty profoundly affected, as are the interests of private property owners elsewhere in British Columbia in some ways as well, in terms of the precedent that the case sets. So that's where things stood. The Cowichan didn't establish a claim to the entirety of the Aboriginal title claim area, but to a significant part of that in an urban area in terms of this doctrine of Aboriginal title. Now, what is the case about and what is it not in terms of the law? This is an important element to bring into things. I'm going to say that what the judge decides basically flows from the Aboriginal title jurisprudence developed in the Supreme Court of Canada over the last number of decades, particularly as expressed in the Chilcotin or Silcotin decision from 2014. It enunciates a test for Aboriginal title, that land is actually owned by an Aboriginal community, a community in the sense of a rights-bearing community. It's a technical term used in the case law. It's owned by an Aboriginal community if that community had exclusive sufficient possession of that land at the time of the assertion of European sovereignty, which in many parts of British Columbia is 1846, but does differ in different parts of the country. There was a third element to that test in the Chilcotin or Silcotin decision and in the earlier cases, but in 2014, when the Supreme Court of Canada rendered that decision, they clarified yet again in some ways that the third part of the test, continuity of occupation, only applied if a community was relying on present occupation to try to prove past occupation. And so it was just an evidentiary option. All that was required to establish ownership of land today, according to Aboriginal title, is that there had been exclusive sufficient possession of that land at the time of assertion of European sovereignty, and that Aboriginal title hadn't been extinguished in the time since, which required clear and plain intent to extinguish that Aboriginal title, and so forth. That's the decision that's basically behind this case. It built upon several prior Aboriginal title decisions from the Supreme Court of Canada, but Chilcotin or Silcotin was historically significant actually in being the first ever judicial declaration of Aboriginal title to a specific area of land in the Canadian courts, even while there had been prior decisions that had accepted the idea in principle. But there's surprisingly few cases that built up this case law, and I just want to mention that momentarily, and then later I'm going to come back to one of the earlier ones. The Silcotin or Chilcotin decision in 2014 followed upon 3 prior Supreme Court of Canada decisions in the whole course of time since the 1970s on Aboriginal title. So there was the Calder decision in 1973. There was the Delgamuke decision in 1997. There was the Marshall and Bernard decision in 2005, and then the Silcotin or Chilcotin decision in 2014. That's all the guidance there's been from the Supreme Court of Canada on the doctrine of Aboriginal title. Those cases have left loose ends and ambiguities, and I've written on Silcotin or Chilcotin before, highlighting a number of those. But there are things that come clearly from it, including that main test. So I'm going to say that's what the court is applying in Cowichan. It's not really applying some of the things people have thought maybe had affected the decision, or not in any large way. So the Cowichan decision is not really about the Declaration on the Rights of Indigenous Peoples Act or the United Nations Declaration on the Rights of Indigenous Peoples, DRIPA or UNDRIP. There's momentary reference, but that international declaration and British Columbia's adoption of it do not fundamentally affect the reasoning within the case. The case is not really about the Interpretation Act amendment adopted in light of the United Nations Declaration on the Rights of Indigenous Peoples. There are other interesting recent cases that are about those. Subsequent to Cowichan, the Gala decision much more recently, and we could talk about that later, but it's not something that bears centrally on Cowichan. The case is not really about other decisions made in respect of Aboriginal title, except one, a little bit. There is some reference to the province's agreement with the Haida, which was a negotiated agreement, and to the fact that the province of British Columbia in that negotiation ended up agreeing to the proposition that Aboriginal title and private property could coexist on the same area of land, which some said was puzzling and strikes me as puzzling, given that each of them is a claim to exclusive ownership of land. Aboriginal title and fee simple, the technical term for a particular form, the largest form of private property owning. In the Haida negotiations, the province of British Columbia ended up agreeing that those could coexist. So the court in Cowichan ends up saying that the province can't really argue that these can't coexist anymore because they've already admitted that they can. But the city of Richmond did and made that argument. So the argument was before the court. The argument was before the court that Aboriginal title had been extinguished, even though British Columbia's litigation policies minimized the making of such an argument by the province, and even though the federal government's litigation directive minimized the making of such arguments by the federal government. Again, the city of Richmond litigated on these points. So those litigation directives didn't prevent the court from hearing those arguments. The case really is about the application of a body of law that's built up in the Supreme Court of Canada case law on Aboriginal title. But it takes things in a different direction. So it's significant in being a major decision concerning Aboriginal title to urban lands, and that creates controversy in itself. Most Aboriginal title decisions, and there aren't a lot of them where Aboriginal title has been achieved, but these have largely been out in different rural areas of British Columbia, or they were argued about in New Brunswick in the Marshall and Bernard, or Nova Scotia in the Marshall and Bernard decision. There are arguments going on in the Atlantic provinces where there's an argument that the mid-1700s treaties there didn't actually cede land. But the successful Aboriginal title claims have been in British Columbia, and they've been in areas where there isn't a density of population in the way that there is in the city of Richmond. And so it's a significant precedent in that way, because that gets more attention. It's easier for everyone just to not pay too much attention when land out somewhere in rural or more remote areas is subject to Aboriginal title, when there are modern treaties reached across all of northern Canada, developing treaty arrangements concerning the transfer of land and self-government powers as well. No one's concerned by that. There's lots of land there, and so that Indigenous communities have some of that land works for everybody. When there's a decision about land right within the city of Richmond, when there are claims in other urban areas that now look like they have more potential, people pay more attention. Perhaps more significantly though, because that just happens to be where the land is, the implications for private property are what really makes the Cowichan decision one that has potential implications. Now, the Cowichan decision is a decision of a trial court. That's why I want to emphasize that the British Columbia Supreme Court is a trial-level court. The decision is being appealed up to the British Columbia Court of Appeal. It doesn't bind other provinces as a decision of the British Columbia Supreme Court. And other provinces have actually seen, well, one other province has seen a decision a little differently in the time since. There's been a recent decision from the New Brunswick Court of Appeal in the Wolastoqey litigation, and it's at an earlier phase, but that saw the New Brunswick Court of Appeal say some contrasting things. So it's not a definitive precedent that is automatically the law that's going to be followed by other courts, but if it were, it has very significant implications. In the meantime, it is the decision in Richmond, and it is a decision that creates uncertainty within the city of Richmond, most so, but even in other places where the same legal propositions would apply. So I said earlier that it's a decision that doesn't directly make an order concerning any privately owned land. The First Nation wasn't seeking that, and they've emphasized that in the time since, and that other First Nations have actually, in a number of cases, specifically carved out privately owned lands from their claims and said they weren't seeking the transfer of those lands. They weren't even seeking a declaration of Aboriginal title over those lands in the Silcotin or Chilcotin decision. That's a good strategic move if you want to avoid complexity in the case. And so I think that's been done a number of times. In this case, the declaration did end up going over an area of land that include private property, but it wasn't land that the First Nation was asking to be transferred to it. So a little bit different. But some of the city of Richmond land in question was owned in fee simple. This complicated notion stems back to feudal times and so on, the roots of our property law. The city of Richmond owned some land in fee simple, the same form of land ownership as private property owners have. They happen to have acquired that fee simple land because of non-payment of taxes, and so it got transferred to the city of Richmond as a result of that by people not paying their taxes. And so they hadn't purchased this land, which is significant. So there is a great deal of respect in the courts for the individual called the bona fide purchaser for value, the innocent bona fide purchaser for value. Somebody who buys something not knowing that there's a problem with its title often gains a lot of protection in terms of having that thing taken away, just as a general proposition. The city of Richmond was not allowed to put any kind of defense of being a bona fide purchaser for value because the court said they hadn't purchased the land. So they owned the land in fee simple, but in a different way than a fee simple property owner, a private property owner who would have purchased land. As a result, there was no discussion of whether the defense of a bona fide purchaser for value would have an impact on the effects of Aboriginal title. But there was a declaration that fee simple land, well, not just a declaration, a legal conclusion that fee simple land could be subject to Aboriginal title, having priority over the fee simple ownership. And some significant statements there about parts of the Land Titles Act even not being valid and not providing a protection for the privately owned land. So there are immediate problems for those within that area in the city of Richmond that are within an Aboriginal title, an area declared to be Aboriginal title, even where their land hasn't been ordered to be transferred to the First Nation, because there's a question raised about the validity of their title. Those lending are, of course, concerned whether they're gaining any collateral in return for a loan. Those considering investing are interested in knowing whether they actually own land that they're going to purchase. And there could be implications down the road. The introduction even of uncertainty raises questions. There are broader questions for British Columbia if this decision represents the law as to if there's an effect on other privately owned land elsewhere within the province as well, if that decision correctly represents the law. And as I say, it's being appealed. We don't know for sure. There is this possible defense that the city of Richmond couldn't put. Other owners could, but that's a defense that's technically called an equitable defense. There's sort of a body of law called common law and a body called equity, and equity is about trying to provide protections against unfairness of the law per se. But whether an equitable defense in that technical sense stands up against constitutionally protected property rights actually raises a lot of questions. And so I think there's the possibility that there's some protection there, but you really don't know what to tell anyone on what the implications of this are for private land ownership. And that's the challenge, is that there's uncertainty that arises from it, and even uncertainty has very significant implications. I'll say as well that there's another part I picked up on a little bit in some comments I've made about the case, which is that there's a morally awkward aspect that the case ends up highlighting in terms of how our Aboriginal title test ends up applying. I haven't talked a lot yet about what goes into the decision. There's 500 trial days, over 500 trial days behind the decision. Longest trial in Canadian history. This is at massive legal costs with the number of lawyers and expert witnesses that are involved. These are massively expensive cases to take if a First Nation is taking them in this form. And that's something that people may want to consider in terms of how quickly this has effects elsewhere. It's massively challenging to take an Aboriginal title case and take it through the courts. That's not to say that there aren't implications from this for elsewhere, but it's not easy for First Nations to take these claims. I want to acknowledge that and highlight that. From their perspective, they are seeking a protection of land that they own, and they're facing a lot of costs to do that. So put that out there, but there's an awkward dimension to some of the expert testimony that ends up fitting with the test. And I think it highlights that there may be aspects we want to think about in terms even of our Aboriginal title test and how it works. That test says if you establish exclusive sufficient possession at the time of assertion of European sovereignty, that establishes Aboriginal title. Then you have to talk about what do those technical terms mean? What does it mean to have sufficient possession? And there's been some debate about that in the courts. That can include seasonal uses of lands, which is what the Cowichan claimed in respect of this land on the other side from where they're usually on Vancouver Island. They use this land seasonally as a fishing village. No particular thing to talk about on that sufficiency part at the moment. They also claimed that this was exclusive possession of that land. And to establish that, they had to show that it wasn't possessed by anyone else at that time. And that they had to put in the context of the Musqueam and Tsawwassen actually being nearer communities, and potentially having claims that they may also have used that land if one went with some of the elder testimony that came in from those communities. One of the key pieces of evidence that the Cowichan ended up putting is just that they were a fearsome community at that time. They put in a lot of details about that. It gets really gruesome, actually, in the full trial judgment. And I don't say this to say anything bad about the Cowichan. There's obviously been lots of gruesome elements to human history if we go back in time. I just think it's morally awkward today to say that your claim to land is enhanced by the fact that in 1846 you can put in evidence that you scared off other communities from entering this land by having heads on spikes, by taking slaves from those other communities, these various pieces of evidence that the Cowichan put in defense of their claim. Like normally those would be things that if they're in a trial judgment, they're negative for the party that has those attributed to them. Those could have negative legal consequences. And our Aboriginal title test has somehow now worked such that those are actually things that enhance a land claim. And the Cowichan are putting in some of the difficult facts of human history in a way that supports their Aboriginal title claim. But this doesn't actually fit with the reasons why we're recognizing Aboriginal title, which is to respond to colonial taking of land. And now you're putting in defense of Aboriginal title claims, a violence towards other communities that was successful at that time in holding off those other communities. It's a complicated and delicate point, but I do think it's something that arises from the case as raising some questions. It's not the main thing I want to talk about. I want to focus in, obviously, on the thing that will be of most interest in terms of the private property issues. And time's going very fast here, so I do need to move along too. I told Jeff that it was at risk that I would go past time if I don't really watch myself. So I've said the case is based on Canadian Aboriginal title case law. That Aboriginal title case law has now led us to a point where it seems that the doctrine of Aboriginal title could allow a taking of privately owned land acquired by innocent purchasers, depending if this were applied by other courts, which the New Brunswick Court of Appeal has said some different things, depending if it were taken up in exactly that way. How do we respect both Aboriginal title and the property rights claims of others who've acquired land in the course of their lives and their families' lives? That's the question I want to ask and that I want to respond to, because I think there's a rightness in both claims. And this is where I could start to get in trouble, because since the Cowichan decision, to a degree that's actually surprised me, there have been more and more people coming out challenging the idea that Indigenous communities ought to have a claim to this land. There's a law professor who's said that he doesn't think we should have Section 35 in the Constitution, the Aboriginal rights provision in the Constitution, who's said that there shouldn't be any Indigenous rights claims because those aren't claims of just of individuals. And I don't agree with his arguments. If we don't also respect the claims of communities, I don't know how we have a nation of Canada, for example, if you say that everything is just about individuals. Well, then why can't just any individual come here? Well, no, we have some claims as a nation of Canada, as a Canadian people. Indigenous peoples were here before. They continued in occupation of certain lands. Some Indigenous communities had concepts of privately owned property. If you go back to the Calder decision in 1973 and read the evidence that was put, a lot of the evidence put was of private landholding within the Nisga'a Nation by individual families within the Nisga'a Nation. And so it's actually not surprising when the Nisga'a Nation reached its treaty agreement, they actually negotiated to be able to run their own land registry for individual property interests for Nisga'a citizens. So even if you're talking about were there individual property claims, well, there were. I think it's a good thing about Canada that it followed the general British imperial practice of trying to respect prior property rights claims. And this is what the doctrine of Aboriginal title comes out of. Different places that the British Empire spread, it actually recognized prior property rights claims. You can say it did so imperfectly, that it allowed taking of some things. This is true. But it also has a legal respect for prior claims, and that's something that Canada has followed within. And a lot of other countries have a doctrine of Aboriginal title similar to our own as a result of that. Variations upon it, but that's the one piece. At the same time, I don't think it's right that Indigenous claims prevail over private property today, and that a small percentage of the population would own all of British Columbia today, which, depending on the version of Aboriginal title doctrine you went with, this is where it could end up. After the Silcotin decision, the ambiguities in it led to some very different perceptions on its implications for British Columbia, and you had some First Nations representatives saying that it meant that 90% of the land in British Columbia would be claimed under the doctrine of Aboriginal title. That doesn't make sense today in terms of respecting everybody, that one would reclaim so much land as that. And so I think we need to find a course that respects both of these. And I'm actually going to say that some earlier Supreme Court of Canada decisions may have done this better than the later decisions. There's a break in those 4 decisions I set out before. The Calder decision in 1973 is rendered based on the common law, a common law doctrine of Aboriginal title that's developing in different jurisdictions within the common law around the same time. It's based in part on a Privy Council decision from the 1920s, the Judicial Committee of the Privy Council. That used to be the highest imperial court. Still is for some countries a court of last resort, but it was our highest court for a long time in Canada. There was a decision not from Canada but from Nigeria that was very influential in a number of later Indigenous title cases. And Canada's Calder decision references that case. Well, when Calder is rendered in 1973, this common law doctrine of Aboriginal title, what it ends up respecting is areas where there's current possession and there's been that possession since time immemorial. Now that's all the land over which the claim was put, but the court phrases things in terms of that. It's a complicated decision because it's not just one judgment there. There's a split within the court on whether the Aboriginal title claim had been extinguished and so on, which technical legal term there. But the decision focused on respecting the title claim and acknowledging a title claim for Indigenous communities and Indigenous nations still in possession of land that they had possessed since time immemorial, where there hadn't been a specific step taken by the government to extinguish that title. In respecting that, one isn't taking land from anybody else because there's that current possession in place. Subsequently to 1982, when we had the adoption of the Charter of Rights and the Section 35 Indigenous Rights Clause, the Supreme Court of Canada's Aboriginal title cases, the other 3, the Delgamuukw decision in 1997, and then Marshall and Bernard in 2005, and then Silcotin or Chilcotin in 2014, they've swayed back and forth on what the law is. As between Delgamuukw and then Marshall and Bernard and then Chilcotin, you have very different versions on the law. They sway back and forth because the court is no longer applying the common law doctrine of Aboriginal title in the form it applied in prior to 1982. It's applying a sense of what's just. They have a phrase in one of their other Aboriginal rights cases that the point of Section 35, the Aboriginal Rights Clause, is to achieve a just settlement. And they say that they're interpreting the claims in terms of what will best support reconciliation. Reconciliation actually comes out in Supreme Court of Canada cases much before it comes out in general discourse, and the meaning shifts in the course of the cases over time. Different discussion there, but they keep referencing the same term and say that they're trying to decide what doctrine will fit with reconciliation. And in the course of this, they end up enunciating this test that I've ended up describing, the one in Delgamuukw, and then in later on in the Silcotin decision, that focuses on this exclusive sufficient possession at the time of assertion of European sovereignty. They impose some extra limits on uses of Aboriginal title land by Indigenous communities themselves. So in the Delgamuukw decision in 1997, they say that Indigenous communities can't make use of their own land, their own Aboriginal title land, in a form inconsistent with the way that they proved that they used the land before. And there's some strange examples there because nobody was putting the claim to do this at the time, but the court ends up saying, well, that you can't use former hunting land to engage in strip mining, and you can't use land that was used for some culturally significant purpose to build a parking lot. Those are specific examples in Delgamuukw. There's a couple of paragraphs there. And I always think the judges had been listening to Joni Mitchell or something and thought that they wanted to write, you can't pave paradise and put up a parking lot and so on. Because where else did this idea come from? And if you're going to say the Indigenous community owns land, why shouldn't they be able to have a parking lot in 1997 or in 2026? It's always struck me as a strange limitation that the court also ends up imposing, and so I've in fact critiqued this before in terms of aspects of how they changed from the common law doctrine to a constitutional and vague doctrine where they've ended up both imposing limits on Indigenous communities themselves, but also opening up the scope for uncertain claims to land more broadly. And I think that there would actually be much to be said for applying something closer to the Calder doctrine and focusing on land where there continues to be possession. And there's been that possession since time immemorial. I've actually argued for a variation on that, a more complex variation in an older article in the Alberta Law Review, but just for simplicity, I'll say that much and say if one focused on that sort of approach, it would actually be more consistent as well with the United Nations Declaration on the Rights of Indigenous Peoples and what it says about Indigenous land claims. Articles 26 through 29 of UNDRIP actually have some very fine distinctions in the language in relation to land that continues to be occupied versus land that was occupied in the past but is no longer occupied. And these don't usually get discussed. But my claims are actually, I think, consistent with UNDRIP. Even though I'm saying that I think there needs to be more limit on the scope of land that's subject to an Aboriginal title claim. Now, this won't work for every Indigenous community. Some were dispossessed of lands entirely, and I do think there needs to be a response in fairness to that. I'm just not sure it can easily be done through the courts. But the courts may have a role. We can develop some more complex concepts there. But I'll just say that in terms of what the courts go about ordering, if they ordered based on Calder, And then we still developed some additional ways of responding fairly to those situations of dispossession. That would also be consistent with those provisions in UNDRIP, and I think would actually be respectful of all interests in a larger way. The other piece of case law that I'll say briefly could be picked up upon more is in the Cowichan decision. There's a reference to Australian jurisprudence, and someone objects to the Australian jurisprudence because we've just lost lights, but in the Cowichan decision, there's a reference to Australian jurisprudence. So if you're going to have a larger test for Aboriginal title, as in Cowichan, it's interesting, the court cites to a case called Ward and Western Australia. One of the things that case says, it's not the point it's cited for in the case, but one of the things that case says is that they don't actually apply a doctrine of extinguishment where you had to have a clear, plain intention to extinguish specific land claims. That makes sense, actually, in the Calder context, where the test relates to land over which there's still possession. Well, if you're going to take away that land through legislative action, it has to be really clear. That makes sense. But if you're going to have other land subject to an Aboriginal title claim, the Australian case law on extinguishment says that the allocation of land to inconsistent uses actually amounts to an extinguishment of the Aboriginal title claim. And I think, and that's without then the same explicit intention, which is something that causes a division of powers issue in Canada. If you say you have to have an explicit intention, it may be that provincial legislation can never change Aboriginal title lands. This approach, focusing on allocation of land to inconsistent uses, would also provide a response rooted in an element of the case law, although an indirect element of the case law, that would find a way of respecting, again, both significant Indigenous claims to land, but also respecting non-Indigenous claims based on the society that has ended up also growing here. So I think there are things the courts could do in terms of drawing upon their own past case law after Cowichan to respond to the challenges posed by Cowichan. If they don't, I think we've seen some of the public response. Some of that public response, frankly, is not good. It's not good for reconciliation or any of those aims to have some of the kinds of responses that have come. But not everyone can explain themselves well in the way that a judge might want them to. People say tough things because that's their way of expressing something sometimes. People aren't sure what to say sometimes, but they know that they don't accept some of the conclusion. There is likely to be a response outside the courts if the courts don't have a way of responding to this. And maybe both will happen. It's very possible that we will see some kind of legislative or constitutional response ultimately to the decision in Cowichan. And particularly if that were upheld in the further courts. I'll just say one might be able to do some things through legislation in a province, although there are challenges around the division of powers questions insofar as lands that are Indigenous lands have a particular relationship to federal jurisdiction. But there are people probably thinking about, are there things that a province can do? Apart from the province acting alone, you have the question, could there be a constitutional response? And I don't urge a large constitutional response. I know there are some, surprisingly to me, who came out and said, well, we should get rid of Section 35 of the Constitution Act 1982. I think there can be a tailored and careful response. And I wrote an op-ed in the summer saying that the province of British Columbia and the federal government together in the fall, could pass what's called a Section 43 amendment, which is an amendment to the Constitution that affects just one province if they were trying to respond to this specific situation and this specific question within British Columbia. And so when people say, well, can there be constitutional change? It's very difficult in Canada. There can be certain kinds of focused constitutional changes without the entirety of the amending formula. And I know that there have been people in the time since talking about that solution. It's been in the media and on social media. And there may be at some point such a response, again, depending what the courts end up doing. We are not tied simply to what the courts decide. If they decide that based on an unrealistic approach that doesn't respect all interests, we can devise solutions respectful of all, including of Indigenous communities and of non-Indigenous communities. And in doing so, it's not necessary to go and take away Indigenous lands and say, get rid of Section 35, as some have done, as some have urged. We don't have to abandon efforts to respond in a general way to the values of the United Nations Declaration on the Rights of Indigenous Peoples to respond to the specific issues that have arisen. There can be debates on how that should be interpreted. It is a set of international norms. Whether they should be in legislation or not in Canada, people have differing views on. But Canada is a country that respects Indigenous rights, and it can continue to do so while also respecting the interests of non-Indigenous property owners. There can't really be Indigenous property rights and non-Indigenous property rights in full forms to the same land, but there can be reasonable responses that recognize the land rights of all. And in that, there are roles for everyone to play, roles for the courts in terms of the doctrine that they develop, roles for legislators, policymakers, constitution makers in terms of responses in which they might engage to help offer clarification. And there's roles for citizens and communities in having good conversations. And we'll have a discussion period here. You may disagree with me. You may disagree with me from both sides. We'll see. But if you agree with me, I hope that some of you can go back and talk to others about the idea that we can actually have shared possibilities together, that we can find ways of respecting the interests of all communities and having shared futures together that do show that respect and that enable everyone to live together in constructive ways while having respect for rights of all types, but offering interpretations that make that work for everyone. So I'll stop there. I've put this a bit informally. I've put it a bit provocatively maybe at spots, but I'll stop there and leave it for questions.